Yes.
Yes, my lord. I am for the appellate petitioner, my lord. Incomplete. Same thing, my lord. Incomplete PCR has come.
ডিটেকটিভ নাকি ডিটেকটিভ নাকি
PCR,
ও
incomplete is
ও
defective.
এক নম্বর এটা
All right. Defect is minor, be ignored, paper books, 6 weeks.
Yes, my lord. 6 weeks. 6 weeks.
মানে
My lord, I am for the petitioner. তোমার সাপ্লিমেন্টারি করা উচিত ছিল। My lord, there is a direction to meet the investigating officer, my lord. I have met the officer, my lord.
Lordship will
I
kindly
complied with that direction in item number 5.
Lordship will kindly remember it is that matter where from the complainant, who is the landowner, this petitioner and his other associates, they demanded 20 lakhs and 4 katas of land. And they are the local goons. They are taking
My lord, this
taking
20
money,
my
claiming money from all those persons who are going to construct a
My lord,
building
these are
in a 1
exaggerated
kata
versions,
land.
my lord. 20 lakhs is not there in the complaint.
He
My
has
lord, on
2
the-
antecedents also.
Very well.
He
My
is
lord,
a member of a village panchayat.
We have understood.
This panchayat, this complainant, basically he purchased a property for development.
Political party is a
Yes,
different.
yes, I'm not supporting anyone.
No, this is
Person-
different political party.
No, no,
Them.
yes.
No,
Now,
I'm for-
that
Faction fight.
there is no fight, Marat. They are running a extortion racket and a village police and everyone
Yes,
is associated.
what resulted in interrogation? How many complaints are made against him with
Lordship,
regard
he
to-
has 2 other antecedents,
What
2
are
other cases. Lordship kindly says these are the 2 cases.
Tell us, he met the investigating officer. What is the result of the investigation?
Lordship, one
It's a
case
promise to marry case also.
is
my lord, I can't say anything.
Extortion is
And Marat, the GDs, Marat, there are 2 incidents.
you're a romantic extortionist.
There are 2 incidents apart from this FIR. One is the
Sir,
complainant.
that is exactly what we want to
Marat,
know.
one is the
That this is not a one-off case.
Marat,
What is his case? That they had a little temple, they wanted a little temple to be set up. So there was a negotiation.
My
As
lord,
per-
my lord, we have a
temple.
temple, existing temple,
For a-
adjacent land.
for
My
a-
lord, that is why he
adjacent
wanted to develop the temple.
No, Marat, there is no question of 7B, 7B.
Mr. Nondi,
Why 25 lakhs,
Mr.
20 lakhs?
From
Mr.
it is not the
Nondi,
complaint also.
show us that it is not, please, show us it is not only the temple. This sort of activity has been carried out by them in respect of others
Marat,
too.
others, Marat, no one
no one is
there.
coming.
No one is coming, Marat.
Then how
Lordship,
can
No
we
one is
pre-
coming.
even in a 1 kata land,
My lord-
whoever
my
is
lord-
constructing,
My lord knows, Marat, going against a panchayat member in a village, it's very tough. Now, Marat, after this FIR, this complaint.
another person has been granted anticipatory bail?
No,
No,
no.
my lord, he was arrested. Your
He
lordship
was arrested,
directed to
Marat,
file an
and
affidavit.
filed
Yes,
an affidavit to
where is that
score,
affidavit?
Marat. This is the affidavit.
Let
Marat,
us see
initially
why
the-
purpose of arrest is necessary.
My 35-3 notice, they have been to his house was locked and key. Now, Marat, after the incident, what has happened? These persons again
Okay.
went,
An application for anticipatory bail in that case was
no,
pending.
the application for anticipatory bail was filed prior to the arrest.
Correct. So why did you arrest when they
Marat,
were
there are GD's entries against them before that. And Marat, this person, this village police, Marat, he is not only, Marat, it's going on. This Marat will kindly peruse this.
See, order sheet গুলো কোথায়?
The conduct of this village police. And this is not a new case. These are old cases against this village police. He's running a system parallel to the police.
And still he is in the
is Amar Jana.
Yes,
He is a village police officer.
yes. And he was suspended by the SP. This is nice. And not now, Marat. This is the complaint against him by the other police persons. 3 FIRs, there is a riot in that locality. 3 FIRs were registered. He was the person who was supposed to, he was
So
posted
where-
over there.
you have just said this paragraph. We want to, this is a completely there is no document. Where is the checklist?
Yes. Original CD. Checklist কত পাতা?
Checklist execution দেয়নি। মানে may I get a copy of the affidavit?
No, this is not your case. This is with regard to Amor Jan.
No, I'm for Amor also. I am for Amor also.
You appeared for Amor.
My lord.
You will get the one. Give you a copy of the affidavit to them
My lord, I will.
appearing for Amor.
I think তুমি দুটোকে অ্যাপিয়ার করছো?
হুম।
একটা কপি দাও একটা।
Along with the checklist is not annexed.
প্রত্যেকে এসো।
Now let us see the forwarding memo.
ফরওয়ার্ডিংটা দাও। মানে মে আই জাস্ট টিক দাও।
This should have been annexed to the petition.
Yeah, I am not. Amor জানাটাই বলছি।
পেজটা বলো।
অত বেরও পাইনি তো। এখানে সিডি আটকে রেখেছি।
সিটি প্রডিউস করছে
হ্যাঁ।
অ্যারেস্ট আমাকে জানায়নি অ্যারেস্টের মধ্যে
সব জুনিয়র।
My lord, I have not been granted bail. The case diary is never produced before the learned magistrate. My lord, they are taking the plea that fine it is before this honorable high court lying. My lord, from that day, my lord, till date, I cannot be granted bail by the learned magistrate for non-production of the case diary.
What photocopy of the case diary?
My lord, I have the order sheets গুলো দাও।
অ্যারেস্ট মেমোটা
হ্যাঁ, আছে তো। মাই লর্ড দেখে নিক তারপর বলছি। এফিডেভিটে তো ওরা যেটা বলেছে, ওরা অ্যারেস্ট মেমোতে তো আমার ইনফর্মও করেনি, আমার কোনো আমার রিলেটিভকে ইনফর্ম করেছে, করেইনি তো, কাউকে ইনফর্ম করেনি। না, অ্যারেস্ট মেমোটাও তাই, চেকলিস্টের কপি আমাদের দেয়নি তো।
এসব হয়েছে 12:40।
এটা বের করো তো।
I see the checklist. Which part of the checklist is there in the forwarding memo? In your checklist, you say that we will explain the parts which have been ticked in the forwarding memo. Now, what have you stated in the forwarding memo?
I've seen. But so far as the last two pages,
Lazy exercises, Mr. Nondi will not do.
the last page of that forwarding, Marat, there's a thread.
Where? What thread?
Yes, Marat, there has been a GT which has been registered.
Please see the memo and tell us
কিছু বলেই না
from the
This is
checklist
important.
which one is satisfied. You have almost checked every box. Chance of committing further offense, etc. Now, if Amor had antecedent, didn't you have the duty to place it before the judge?
এতে ফরওয়ার্ডিংটা, ফরওয়ার্ডিং তো ওই স্টোরিটা নেই।
In the checklist.
Now, which part should have been?
First, what did you
First is that arrest necessary for at least one of the following should be yes. Preventing the accused from committing any further offense.
Where have you stated that there is propensity of further offense in your
But in the last paragraph of the forwarding, the above noted accused have been continuously threatening the
Bus,
complainant.
one line.
Lastly, on
Hmm.
24/1/25 in the morning, the accused came to the complainant's office, demanded this.
Then that is the offense.
No,
এটা তো একটু
But absolutely, Manoj,
Hmm.
regarding the subsequent
Where
GDs
is
and
Is there in the case
That is- that is-
forwarding
that
report?
is not there.
Then
That is not there.
where is your compliance of Arnesh Kumar?
That is not.
Is the law declared by the Supreme Court just for the law books? Or there should be some trickle down impact to the level at which the police action takes. There's repeated monitoring, everything, training, what? Why? And it is a case, as you say, of some importance. If case of some importance is given so little adherence to rule of law, who is going to be blamed, sir? And look at the way you have ticked. Every box is ticked. And when it comes to and what you say, the elaboration in forwarding memo. We asked for the forwarding memo. Apart from a laconic statement that complainant received threat, nothing, zero.
GDs should have.
What subsequent? What about his antecedents? That this man is involved in this activity, he has got this antecedent, he has a chance of committing similar offense. No statement of that fact. Second, running away, chance of abscondence. Thirdly, threat, a vague statement, nothing, no particulars which you say GD is registered, it's not produced. Is this compliance?
Should have been mentioned.
Then we know should have been mentioned. So let us reject his bail and send this police officer also to jail beside the accused for not complying with these directions.
But so far as these officers is concerned, Manoj, I will have a talk with the SP.
What we would have a talk with? How many talks, Mr. Nondi? When is Arnesh Kumar delivered? And then until and repeated meetings, repeated training sessions, and this is the impact. This is the result that we see at the ground level. Yes, Mr. Your client has substantial.
My lord, Amor. So for Amor,
Amor,
my lord,
Amor.
he is in custody.
Yes, so
He is
we
in
pass orders for Amor first, huh?
But my lord kindly considers the arrest memo also. In the my lord, in the affidavit, I find my lord it's a claim of the officer that he went to the house of the Amor. He did not find it was under lock and key. Now, my lord, he is arrested from the same village, and my lord, none was kindly sees the arrest memo. No signature of any of the relative is there. Nothing. And my lord has elaborately discussed about the checklist and everything. My lord, we all are there in the village. I was arrested from the village. My lord, there is a
Where is
different
the arrest memo?
arrest memo I have. The photocopy.
Where is your residence?
Amorer residence.
Mirhati. You were arrested at Santoshpur Mall.
সন্তোষপুর কাছে পাশেই তো হুম
Where is Santoshpur Mall?
সন্তোষপুরটা কোথায় বলো
সন্তোষপুরটা কোথায়?
যেখান থেকে অ্যারেস্ট করেছে সেটা তোমাদের ওখান থেকে তো মানে হ্যাঁ
সাবাসী
800 meters.
800 মিটার
From Mirhati.
From,
800 meters from where?
from his residence.
from his residence.
From his residence. So no signature of any relative or local person. Why? Sure. Petitioners, Omori, investigating officer has submitted a report, submitted explanation with regard to non-compliance of, please give us the memo where this, the checklist and the forwarding. list. Explanation with regard to arrest, আগে দাও, during the pendency of the application for anticipatory bail, the petitioner was arrested. In these circumstances, we called upon the investigating officer to submit explanation in respect of compliance of the directions in Arnesh Kumar. Good stuff. Investigating officer has submitted report
Para 8 is when he was arrested, 12:40 hours. And para 10 is at 14:01 hours. The message to the electronic means was received regarding his filing of the anticipatory bail. Para 7 I have mentioned regarding the GD.
Yes. Where is the
GD entry, para 7 I have mentioned.
paragraph 6? Where is the GD entry with regard to, or case diary entry with regard to 31/2025?
My lord, this demand was neither in the complaint nor even in this affidavit, my lord. This is this is the latest development immediately after lodging of the complaint and filing of this application before this honorable court. This was never there in the complaint also. My lord, kindly seize the letter of complaint. It is all about threat to ransack the office and, my lord, ransack the car. We never demanded any money from them. টাকার গল্প তো কোথাও ছিল না। হ্যাঁ?
Paragraph 6. You have said that you went there to serve a notice under 35(3), but everything was locked. Where is that GD? Case diary entry.
172 papers. My lord, first flag. First flag.
YOLO.
First is the red GD incorporation. Next is
টাইম অফ জিডি কত? এই টাইম অফ জিডি কত?
কি বললাম জানো?
My lord, in the night they went to serve notice. In the night, on 30th January 2025.
Yes.
My lord, immediately thereafter, they lost this GD that I was in the night,
Not GD, entry in the case diary.
entering the case diary. In the night itself.
Yes, yes.
In the night. Ganesh Kumar. Explanation is placed on record. In the explanation is placed on record. Copy of the explanation is handed over to learned counsel for the petitioner. Heard learned counsel for the parties. We have perused the checklist. In the checklist prepared under checklist, in the checklist, it is contended that the arrest was made from the averments in the explanation. It is alleged that the petitioner had threatened the de facto complainant on 31/2025. On the same day, around 9 p.m., the investigating officer went to the residence of the petitioner to serve notice under 35(3) BNSS, but failed. On 14/2/2025, again, the investigating officer received information that threats have been held out to the victim. As a result, on 18/2/2025, at 12:40 hours, he had arrested the petitioner. The arrest was prior to receipt of intimation. He had received intimation with regard to pendency of the anticipatory bail application on the same day at 14 hours. Full stop. We have considered the explanation in the light of the checklist submitted before us, checklist and the forwarding report submitted before us. Though the checklist shows that the arrest was made to prevent the accused from making threat to witnesses or cause disappearance of cause disappearance of evidence, preventing accused from further crime, and proper investigation of the case. The forwarding memo is not happily worded. It does not refer to the antecedents of the accused, which would give an impression with regard to his criminal propensity and possibility of committing offense in future. The report is singularly silent in respect of the threats received by the apart from a laconic statement. The report is singularly silent with regard to the threats held out to the de facto complainant and other witnesses on 31/2025 and 14/2025. Mr. Jana submit that these events have been subsequently manufactured to justify the arrest. He also contends that the arrest memo does not bear the signature of a relation or local witness. We would have in light of the in light of the in light of the indifferent and callous manner in which the forwarding memo was prepared, we would have otherwise, we would have ordinarily accepted Mr. Jana's submission. But deeper scrutiny of the facts show the the failure to disclose the earlier threats in the forwarding memo is callous indifference of the investigating officer, but not incidents manufactured later on. We are persuaded to hold as such, we are persuaded to come to such conclusion as the threat held out on 31/2025 was contemporaneously diarized as General Diary entry number 1925 in the records at the police station. Additional public prosecutor has also placed before us the criminal antecedents of the petitioner, namely so and so criminal antecedents of the petitioner, which gives a propensity with regard to his with regard to the possibility of his committing similar offense in future. Directions in Arnesh Kumar, in future, the materials on record justify the reasons reflected in the checklist reasons justify the reasons set out in the checklist justifying arrest. There is but we disapprove the callous manner in which the forwarding memo was prepared without disclosing relevant material supporting the notings in the said checklist. One of the prime requirements in Arnesh Kumar is that the investigating officer must satisfy the jurisdictional magistrate with regard to the reasons and justification for arrest. Full stop. Merely ticking the boxes in a checklist is not enough. The notings in the checklist must be supported by foundational facts justifying the reason for arrest. This has not been done by the investigating officer, and this has not been done by the investigating officer, and we hold investigating officer. But the materials on record, which the materials placed before us, which the investigating officer, for reasons best known to him, failed to disclose in the forwarding report, justify the arrest. Accordingly, we do not wish to initiate contempt proceeding against the said officer, but we direct him to be careful in future. Full stop. We also request the Director General and Inspector General of Police to undertake measures for undertake supervisory steps to ensure real and substantial compliance of the directions in Arnesh Kumar and Satyendra until full stop. The proceeding is closed. Now let us come to the next.
My lord, in the second case, my lord, I have complied with the direction of this honorable court. My lord, there was a direction to meet the investigating officer immediately. My lord, I have complied. I have handed over. My lord, I do not have.
Petitioner submits.
He is the Pradhan, my lord. He runs the entire thing.
And he demanded 20 lakhs and 4 katas.
My lord, the story of 20 lakh
20 lakhs is not there.
was never there.
4 kata is there.
164 there.
In the 164 it is there.
FIR not there.
If I
My lord, this 164 is recorded after.
Petitioner submits that he is a member of a
I am a Panchayat member. Panchayat member?
no the
No, Gram Sabha.
Gram Sabha. He is
Gram Sabha.
member of a Gram Sabha
এই তো?
which
গ্রামের একটা
used
সভা
to
হয়।
which manages a temple. Full stop. Petition de facto complainant had purchased a large tranche of land adjoining the temple. The Gram Sabha requested the de facto complainant to hand over 4 kathas of land to develop the temple. There was no allegation of demand of money. Allegation of extortion or demand of money is an afterthought. Petitioner has cooperated with investigation. He prays for anticipated. Learned lawyer for state opposes the prayer. He contends petitioner is the Pradhan of the Gram Sabha. He, along with his associates, including the civic volunteer Omar,
Member of the Gram Sabha.
huh?
Member of the
member,
Gram
Pradhan, he the member, he along with his associates, including a civic volunteer, is running an extortion racket. Out of fear, local people could not raise protest. He demanded money. He demanded money and land from the de facto complainant who had purchased land to develop the property. Full stop. His associates have held out threats. During investigation, his associates held out threats. Full stop. Custodial interrogation is necessary. We have considered
and
the
he has two antecedents. Two antecedents of
Acha.
this petitioner. Number 5.
He also has antecedents.
Lord
He,
TV, he has 2 other
he
antecedents.
has criminal
I
antecedents.
promised to marry.
Promised to marry.
And another is 326
Another is assault.
assault.
26.
One is promised to not promised to marry. It is cohabitation on a false marriage.
False promise.
He went to extortion. He went somewhere, put sindoor on the forehead, started staying with that woman, saying, "I am married."
Witness is Mr. Ashraf Ali. Ashraf Mondol.
In that case, Mr. Mondal, you should not embarrass him.
My lord.
We have considered the materials on record. Petitioner is a member of a Gram Sabha. Allegations leveled him and his associates are very serious. It is alleged that they ran an extortion racket
My lord, I undertake to reside outside the
and
jurisdiction.
has threatened the de facto complainant who was developing a property in the locality and had extorted the de facto complainant who was developing a property and demanded land and cash. Full stop. it is contended the demand of cash is not reflected in the first information report. But the totality of materials collected during investigation clearly shows role of the petitioner as a member of the group who had demanded, who had made, who had raised illegal and unjustified demands of land under threat, land under threat of dire consequences to the de facto complainant. The nature of allegation partake an organized crime activity. Full stop. Petitioner has criminal antecedents. His associates also have criminal antecedents. Full stop. Petitioner submit in this backdrop. Now, keeping in mind the gravity of the offense and the possibility of commission of similar offense in future, we are of the opinion custodial interrogation of the petitioner is necessary, and this is not a fit case to grant it.
I'm good.
But Mr. Nondi, we have given a reprieve to your officer. We are not at all happy.
No, but even
Please, when you are ticking the boxes, relevant data should be given in the forwarding report when the accused is produced. Full stop. Huh? Until ANTIL.
My lord, in terms of we are being strict. My lord, initially there was a proclamation issued, my lord, against the petitioner. Legality of that has been challenged before this honorable court. That has been set aside, my lord. My lord, my lord, one constable was, my lord, beaten to death.
We have considered the materials on record, statement of eyewitness recorded before magistrate, show petitioner and others had assaulted the victim, resulting in death,
4%, one of them
My
died.
lord, may I, my lord,
one of whom died. Accordingly, we are not inclined to grant answer.
Yes.
Next.
Nine, I have.
All I'm for the petitioner. Well, petitioner is the husband. The FIR under old section 498 and 313. Lordship, the dispute started when the petitioner came to know, so love marriage, that the
86 is?
86, I don't understand. It's a definition of mental cruelty.
Huh?
It's a definition of mental cruelty. It should be 85.
85.
It should be 85.
Should be 85.
No, Lordship, the dispute started when we came
All
to
right,
my
what is the miscarriage, allegation of miscarriage?
Let's say, kindly see, regarding miscarriage, I am not getting anything. 58 page and 65.
And 65.
65. Let's say it is Calcutta police.
That is psychiatric problem.
Let's say, I think so.
Petitioner submits that the victim suffers from, the petitioner is the husband of the victim. She suffers from psychiatric ailments. He has been falsely implicated. He prays for answerability. A lawyer for the state produces the case diary. We have considered the materials on record, including the medical papers. Statement of witnesses and medical papers show a victim was suffering from anxiety and psychiatric problems. Keeping in mind these facts, we are of the opinion custodial interrogation is not necessary and petitioner.
Then, my lord, I'm just praying for a day's accommodation.
302.
Just not today.
Can it be Monday, my lord? Can it be Monday?
Then I'm for the petitioner. I'm for the petitioner. My lord, both the parties, de facto complainant and the petitioner, both are living in the same premises. My lord, in the different floor, my lord, regarding to put some ingredients in the dhunuchi, my lord, some smoke arises and that's why there is a conflict between both the parties.
Injury, let us see. Petitioners submit that they are residents of the same apartment. Dispute cropped up over a trifling issue, namely burning coir. They have been falsely implicated. He has been falsely implicated. They have been falsely implicated. They pray for answerability. Then a lawyer for the state opposed the prayer. We have considered the materials on record, including statements of witnesses. A fight broke out between two flat owners over over lighting choir for religious purposes, full stop. However, injuries do not appear to be grievous. Under such circumstances, we are inclined to grant it. Next,
Next, my lord, I am for the petitioner. My lord, this is 409. My lord, I am the headmaster. My lord, I am having a long-standing feud, in fact, my lord, with the sub-inspector of school, Belda Circle. My lord, regarding that, my lord, I have made series of complaints that is annexed from page number 11 to 52. My lord, your lordship would kindly come to page number 4 of my applications. My lord, I have categorized five different complaints regarding that. My lord, now after so many years, my lord, while I'm on the verge of my retirement, my lord, only to create a problem regarding my lord, pensionary benefits and all those things. My lord, this case has been initiated. Defalcated amount is 1,761. This is a defalcated amount. My lord, your lordship would kindly come to page number 25, 27. Your lordship would also see the statements of the employees as well as other teachers of my school, except one
not
lady.
explaining the midday meal.
My lord, I have done. My lord, kindly come to page number 40. Show cause is my lord, last
But
page
your
of the
reply is
brief.
at page 3 of the case diary, my lord.
Everything I have annexed.
My lord, he has annexed complaints against the de facto complainant. And my lord, also one Gautam Haldar.
I'm concerned about the fight between them. Let him explain the records so far as the midday meal. The main allegation is with regard to
Yes.
midday meal.
Yes.
My lord, 45
Yes.
to 52 is my explanation.
Within a specific.
45 to 52.
Place this before the
My
investigation.
lord, that has been placed. My lord, that has been seized also. That has been
Let
seized.
the investigating officer sit with the inquiry team
Yes, my lord.
and give a report on this.
Yes, my lord.
Petitioner submits. He is the headmaster of the school. The sub-inspector of school has inimical relation with him. At his behest, he has been falsely, at his behest, at the fag end of his career, he has been falsely implicated in the case. He has cooperated with investigation. He prays for bail. Learned lawyer
He has not cooperated with the investigation.
learned lawyer for the state contends petitioner did not cooperate with the inquiry team and gave evasive replies. This is disputed by Mr. Mahapati. In light of the aforesaid submissions, we direct the petition to hand over all relevant papers relating to the midday meal scheme and other affairs of the school to the investigating agency and explain the accounts to the investigating agency. The agency shall be at liberty to contact the inquiry team / accounts personnel for verification of records. Report with regard to progress of investigation be filed on the adjourned date. Petitioner shall meet the investigating officer once in a week until further orders. Matter will appear 2 weeks hence. Subject to the aforesaid conditions, petitioner shall not be arrested for 3 weeks or until further orders. Which
Deep notes.
3 weeks.
Next.
Grateful lordship.
Madam, for the petitioner, in 2019, the present petitioner joined as a sales manager in HON'BLE Pits. Thereafter, in 2021, he received some money, and thereafter he returned back the money. Thereafter, he left the company in the year 2022. In the complaint lodged against the present petitioner in 2023, he has also complied section 41A notice, my lord. And there is a delay more than 1 year, my lord. I have already complied.
My lord, 441A notices were issued. The last one was served at the residence in Madhya Pradesh, received by the
Petitioner
father.
submits that the allegations relate to breach of contractual obligations and do not disclose ingredients of the offense. He prays for answerable bail and a lawyer for state submit petitioner has not cooperated with investigation.
I have cooperated, my lord. Already.
We have considered the materials on record.
Page number 15, my lord.
The FIR, it is alleged petitioner received 488 fish seed bags, but had not paid for the said.
No, my lord, that is not the allegation.
I have already paid, my lord.
Allegation is that he is entrusted with the consignment and everything. Instead of the original consignee, he passed it on to some other person, received money from that end, but did not remit it to the
So
account.
he is an agent.
The
Sales manager.
sales manager of the complainant company.
Money is
Under
already
his
refunded, my lord.
instructions-
Kindly peruse page number 19, my lord. Para 19. The petitioner's de facto complaint said strongly believe that Mr. Anish Bilgorgar may have been contained.
He had controlled all the operations under his
Page 19, my lord. Page 19, my lord.
Yeah.
Annex, the FIR.
and Lordship kindly sees
Yes, what is this?
48. the
Mr.
bank statement.
Therefore, based on the above mentioned circumstances, the company strongly believe that Mr. Anish Bilgorkar may have contained
The money went to
prohibited
his
money
account.
from his opportunity. May. My lord, the chassis mileage
Have you
submitted.
talked, have the persons to whom he has sold been interrogated?
He wrote a letter to the complainant that I find this stock has reached my factory, although I had not placed any such order. That is how the complainant came to know about it. Thereafter, my lord, if your lordship kindly sees page
And who
48.
paid the accused? Who has paid?
Yes,
the-
that is exactly what is page 48.
Huh,
This person, the person who intimated the complainant,
huh.
he paid it directly to the present petitioner.
So if he has
And-
paid it directly to the present petitioner, then if he didn't order for the consignment, then why did he buy it?
For the time being, he said, since I have received it, so he paid it to, but there could have been a conspiracy, my lord.
Ah, there
That is not unearthed. But so far as his complicity is concerned, he received the money. He should have passed it on to the account of the company. That has never happened. In the petition, he claims it came to the account of the
My lord, already
brother.
paid, my lord. My lord,
It is his
5,79,000, my lord, in
Yes,
2020.
paid.
My lord, kindly
There is
pay.
no such
Yes,
instruction.
my lord. I have annexed. Kindly peruse, my lord.
Earlier than-
Document ওর annex টাই আমি
Then who has paid?
এটা কার অ্যাকাউন্টে কোনটা যাচ্ছে কোনটা কোন পেজটা
In 2021, my lord, in 20 May, he received the money. And thereafter, on 24th of May, he returned the money to Lucky,
who is lucky
supplier.
Supply.
it should come to the company, the complainant company.
So Lucky Chand had handed over the goods to him. Then, চল, petitioner submits, কি বললাম যেন? না, in the prosecution alleges, petitioner is the agent of the de facto complainant company. He had sold a consignment of 488 fish seed bags, fish seed bags to a third party and misappropriated the money. We have considered the materials on record, materials on record in light of the submissions made on behalf of the petitioner. Petitioner contends that the amount received where the said consignment had been credited in favor of the supplier, namely Lucky
Fish farm. Lucky
Fish Farm, full stop. In view of nothing is placed on record to show that that Lucky Fish Farm, that the proprietor of Lucky Fish Farm has been made a conspirator in the offense. Under such circumstances, we are of the opinion custodial interrogation of the petitioner is not necessary, but he requests to cooperate with investigation in accordance with law. Meet officer, investigating officer once in a week on further.
My charge sheet has already submitted.
Oh, ওটাও কেটে দাও। Investigation is gone. वो इसको पैसा वापस किया लक्की को, लक्की को छोड़ दिया इसके पीछे। ट्रांजैक्शन क्या है इरेगुलर, हमको ना दिखे
The injury is simple, my lord, but only one person, one female victim, my lord, she was pregnant at that time, though no miscarriage was done, but she was kicked on her.
petitioner
belly.
submits the allegations do not disclose ingredients of the offense under section 109 of BNS. They have been falsely implicated. They pray for answer to pay. Learned lawyer for state submit one of the victims was in the family. We have considered the materials on record, including the injury reports. Injury reports do not show the injuries are grievous. Nothing is placed on record to demonstrate that the assault had impacted the pregnancy. Under such circumstances, we are entitled to that. But then, right, but for the other case, आपके साथ है, कोई other case आपके पास है. Next.
Procedural section 191, 191, 190, 132, 233, 224, 250, 250, and 121 of the assigned 109 of the BNS. 25
Police personnel were attacked and they were obstructed to discharge their personal duty. And in respect of petitioner number 1, 3 criminal cases are pending.
At night, police came to the house of one accused person. They started to shout, "Dagat, Dagat." All the villagers came out. All the 50, 60 villagers came out.
Oh,
So also we came out to.
you came out.
Lordship, kindly come to
Thank
FIR,
goodness your defense is not that we went out to answer nature's call.
No, Lordship, Lordship, kindly come to my involvement, Lordship. We are just villagers. and-
All go to jail.
Lordship, we are villagers, come to see the.
Fun.
No, Lordship.
There is a police bash up going on. Let us see. All
On
villagers,
Curiosity, Lordship, we came out, Lordship.
all of you involved in. Why did police come there? Narcotics.
No, no.
Fire.
Fire.
Ah,
Recover Hasu and fire.
no, gun factory.
No, Lordship. All the villagers, all 50,
All
60
villagers.
Lordship, yes.
Everyone involved in gun
Lordship,
factory.
after, at night, Lordship, they are shouting, Jagat, all the villagers came out, Lordship. Lordship, kindly come to the FIR, Lordship.
Against
Stand aside.
petitioner number one, 3 cases are pending.
All right, what is the injury?
Injury is not a simple injury.
Simple.
Page 54 to
Why tenderness and restriction of movement of right arm?
50 to 54.
We have considered the materials on record, statements of witnesses do not attribute specific or overt act to the petitioners. Whether they shared common object to assault police personnel has to be assessed at the appropriate stage of the proceeding. However, petitioner number one has criminal antecedents. Possibility of his involvement in the crime, his involvement in the crime stands on a higher footing than others. Accordingly, we are not inclined to grant ancillary bail to petitioner number one. Prayer for ancillary bail of others, petitioner number two is allowed.
Get
Fire, COI. Unoটা কি? Unoটা কি? Next. इसको मारे।
May I please, your lordship.
उसके ऊपर
Alert 109, 118, subsection 2, allegation of assault which resulted in scalp injury. Lordship, may kindly consider the injury report.
Lordship, page 27, 28. The Domkol Shodor Hospital, there is scalp injury, sharp cut injury, 2 ladies are injured. Victim statement are there. And last page, 35, 36, Lordship, from Murshidabad Medical College. This is simple.
we have
Lordship, kindly
What?
produce the first medical report from Domkol.
Murshidabad, simple.
Sharp cut injury over scalp and cut injury on face.
Lord, there are 4 petitioners before your lordship.
Eyewitness is there, Lord.
on their face and head.
Skull.
My lord, there are 4 petitioners. Lordship, may kindly consider whether all.
Yes, all.
No, two. কারণে আমিনুল নজরুল সিরাজ ফৈজু
Yes, 4. An eyewitness is there, Lord.
Lord, what my learned friend submitted, my lord, Murshidabad Medical College injury report appears to be simple.
but it's on the face.
Yes.
Lordship, may kindly consider.
Firstly,
Five
Last week
by
they are
five
taken to
each on
Domkal
the
Medical
face,
College.
cut injury on Maksoora Bibi. Cut injury on scalp. Cutting. Petitioner submits that there is prior enmity between parties and they have been falsely implicated. They pray for ancillary bail. Learned lawyer for the state oppose the prayer. We have considered the materials on record, statement of record including injury report. Though injury report discloses injury on face and
Skull.
scalp by sharp cutting weapon, the report also shows the injuries are simple. In light of the aforesaid fact, we are inclined to grant answer.
Great.
They also
that the petitioner happens to be an employee of the Siliguri Municipal Corporation. The allegation is this: she has allowed her account to be used by one of the co-accused for routing the extortion amount. But if the amount was credited to her account, she has repaid the entire amount to that person who has used his account. If your lordship kindly come to page 13, your lordship will find that the 25 lakhs came and thereafter 15 lakhs transferred by way of RTGS and 10 lakhs by cash millet. Few persons has been arrested who were also alleged to be the beneficiary millet. They have been released on ad interim bail.
Yes.
My lord, absolutely an incorrect claim that the money came to the account of the present petitioner from the account of another co-accused. Lordship kindly sees it came from the account of the complainant. 25 lakhs was credited. On that very day, she has
No,
with
from Pranabendhu, 10 lakhs was credited.
no.
But it credited from Sushanta
It
Pal, the
was
company.
Oh,
credited
debited.
from
So, A to
Yes,
Debited.
withdrawn by cash.
The amount-
15 was credited back to Pranavananda.
25 came from Devjani.
Shushanto Pal, who is the complainant.
Sushant. Then 10 lakhs was withdrawn by this lady and 15 lakhs by
And
Pranava.
while the pleading in the petition is
we are
the
saying
amount
Pranava
came
to-
from Pranavananda. That's not right.
Pranavananda.
Pronomen, we have not said that, my lord. Pleading is this, Pronovendo asked us and I have allowed him to use my account.
And he has suddenly passed on 25 lakhs. That is not the scenario which is reflected
No,
from the
that we
bank
have seen.
account. My lord, the complainant is a 72-year-old person. The son resides in United States.
What is the fraud?
My lord, the fraud is that your son will be arrested. There
Oh,
are
digital-
notices. Yes, digital arrest. And that is how this money was taken away from.
Petitioner submits. She is an employee of Shiliguri municipality. He knew one Pranavananda, Pranobendu Choudhury, who had a matrimonial dispute. In connection with payment of maintenance alimony to his estranged wife, Pranobendu had used the petitioner's account to credit a sum of rupees 25 lakhs. She was not aware that the transaction was not a bona fide one. She pressed for anticipatory bail. Learned lawyer for state opposed the prayer. She submits petitioner and Pranobendu had conspired and put the de facto complainant and put the de facto complainant's son, bracketed residing in United States, to digital arrest. Under threat and coercion, the money was extorted and shared by both of them. We have considered the materials on record. Allegations in the first information report disclose involvement of the petitioner, disclose extortion, disclose extortion through digital arrest. De facto complainant is a septuagenarian and resides at Kolkata. Her son was residing in United States. Accused put him to digital arrest, and under extortion siphoned a sum of rupees 25 lakhs from the de facto complainant. Good stuff. It is alleged petitioner is also a member of the gang, and the money was credited and the ransom was credited in her account. Her account, the entries in petitioner's account show endorses this fact. It also shows withdrawal to the tune of withdrawal of 10 lakhs by 15 lakhs by co-accused Pranobendu and rupees 10 lakhs by petitioner. Had the amount been credited by Pranobendu for payment of matrimonial allowances, the withdrawal of rupees 10 lakhs by the petitioner, it would not lead to withdrawal of rupees 10 lakhs by petitioner. In these circumstances, we are of the opinion petitioner played a vital role in the cyber offense resulting in extortion. Hence, we are not inclined to grant answer.
The one thing, the payment of matrimonial, but it was a representation that a sale proceeds of a land.
For what?
And
For what? Sale proceeds of land? for the payment of dues to his wife.
Ma'am.
How will you are not the wife,
Ma'am,
why did you
ma'am,
draw
ma'am.
10 lakhs out of it?
My lord, I am for the petition. My lord, 406, 420 of the Indian Penal Code, my lord, has allowed the anticipated bail application of the principal accused, my lord, who entered into an agreement. My lord, part payments were made. My lord, I was witness
Sale
to
of
that.
bus. He is a witness to the agreement.
Petitioner is a witness to the agreement. Principal accused has been granted anticipatory bail. Keeping in mind the complicity of the petitioner in the crime, we are inclined to grant it similarly. Next.
I'm led by Mr. Asim Jagala.
Below, I am for the petitioner. Below the allegation under section 306, below 108 of this act. Below this petitioner and this victim, below they had an affairs. Below it was alleged that below the both major.
Suicide note.
My lord, this is the note, my lord, which was recovered
This
from
is
the
the
house of the
note.
deceased.
This is the history.
My lord, she has only stated that the present petitioner is a good actor. He played with her emotions, all that, lordship.
খুব ভালোবাসি তোমায়, ভালো থেকো তুমি,
There is
ক্ষমা করো আমায়,
conflict report statement also.
গেলাম সবকিছুর কাছে, পরশুদিন তোমার বিয়ে, ভেবো না তোমার সামনে এই মুখ আর আমি কখনো দেখাবো না, এবার কথা বলবো না। Very emotional.
My lord, an expert report was pending, lordship.
Hmm?
It's pending, my lord.
All right, let us accept it as true.
Lordship. By emotion, she committed suicide.
Both of them were in the performance business. She was an actress.
No, lordship, petitioner is a state government employee, and the deceased person is a
police officer.
Below the assistant police officer, below the ASI. Below these persons below never denied to marry the girl. Below this discord arose below the parents of this petitioner whether below expressed that they disowned the boy son if he married. But below this petitioner categorically Miller requested the girl to wait for some time because time will Miller.
No, lordship, kindly peruse the 164 statement of mother of deceased person, lordship. He denied to marry her, lordship. After that, she committed suicide.
Sure. Petitioner submit that he is submit there was a romantic association between him and the victim. They had planned to marry. Subsequently, the marriage did not fructify. Victim committed suicide. Ingredients of offense punishable under section 108 of the Indian or BNS is not disclosed. Accordingly, he prays for anticipatory bail. Learned lawyer for state opposes the prayer. We have considered the materials on record, including the suicide note. The suicide note and WhatsApp exchanges show an emotional outburst on of the victim as marriage did not fructify between the parties. Full stop. It is a sad reflection, no doubt. It is a no doubt the fact that the romance did not blossom into marriage was an unfortunate one. But an act of self-extermination in a fit of emotional outburst may not always attract the penal consequences, may not always attract penal consequences. The court must objectively examine whether the act of the petitioner, that is, refusal of marriage, was act of the petitioner, that is, refusal of marriage, was calculated to incite the victim to commit suicide or not. No such material is evident from the records of the case. Accordingly, we are inclined to grant answer.
And for the petitioner allegation under section 109 of the PNS Act, Lordship, there is a property dispute between the complainant and the petitioner, Lordship, and earlier the wife of the complainant lodged a written complaint against the complainant and other family members.
Petitioner is the brother of the girl, my lord.
Brother?
Yes, my lord. Brother, petitioner and his wife, my lord, driven away her mother, my lord. So, my lord, the present victim, my lord, raised objection, my lord. Then he assaulted. He assaulted.
Statement 9
Page, my lord, 9, my lord, statement.
Petitioners submit that there was a family quarrel and they have been falsely implicated. They pray for anticipatory bail and a lawyer for the state opposed the prayer. We have considered the materials on record, including Statement of witnesses show petitioners tried to throttle the victim girl. Injury report also discloses injuries on the throat and neck, corroborating this statement. Under such circumstances, we are not inclined to grant answer. Next.
I'm for the petition, Lordship. Electricity Act, Lordship, petitioner has already deposited 50%.
Petitioner has deposited 50% against final assessment bill to the tune of so and so, bill for unmetered consumption to the tune of so and so. Under such circumstances, we are inclined to grant answer to it. इसके बाद तो आपके पास चला जाएगा.
Annex করা আছে, annex করা আছে. হ্যাঁ, pay করেছে, 50% pay করেছে. Grateful, Lordship.
My first jurisdiction was electricity.
Case under section 126, 117, 118, 109, 3, subsection 5 of my lord BNS. My lord, one Lemon Sheikh, who is not the petitioner, assaulted the
Victim. Lemon shake assaulted Kathal shake. Huh?
Two others. Surrender before the
Repeated stab injuries by this petitioner only,
We have
not
considered the
lemon shake.
materials on record. Statements of witnesses show petitioner had stabbed the victims with a knife, resulting in grievous injuries. Accordingly, we are not inclined to grant it. ये कौन शेख है? समीम कमी कबाब.
I am for the petitioner, my lord. Allegation is that, my lord, petitioner and other accused person, my lord, called the victim for a party, my lord, and thereafter when allegation is that, my lord, petitioner and other accused person called the victim for a party, my lord, and thereafter when the
And you-
victim returned to his house,
And you assaulted them
oh,
again.
my lord, both are friends, my lord. Kindly see the injuries, my lord.
What injury?
Both are friends, my lord.
পার্টি করার জন্য ডেকে নিয়ে গিয়েছিল
Bumba is the petitioner here.
নিয়েছে আমার টাকা পয়সা নিয়েছে মাথা ব্যথা বুম্বা
Yes,
Yes,
that is Bapi Das.
Bapi Das Bumba.
then stolen property recovered.
No, my lord, this is not.
My lord, allegation is that,
My
my
lord,
lord,
allegation mainly is, my lord, with the, my lord,
303 is there.
throw him in drain and snatching his mobile and cash 6,000.
How much? Well, we have
Cash
petitioner
6,000.
submits that he has been falsely implicated in the case. He prays for answerable and a lawyer for the
stolen
state of
property
the
not
prayer.
recovered.
We have considered the materials on record. Injuries are not grievous, including medical papers, includes injuries are not grievous. Accordingly, we are inclined to grant it.
Grateful.
Next,
Lordship, my
counter case, this 326, 354, 34.
Simple injury, my lord.
after the materials on record, there was a free fight. Case counter case was registered. Injury report shows shows injuries are simple. Accordingly, we are inclined to grant it. Next,
Lordship, for this state.
A 307 dispute cropped up due to faulty sound system in the Saraswati Puja.
what faulty sounds?
The victim provided sound system in the Saraswati Puja, and that dispute cropped up, my lord.
Lordship, de facto has come with a report. I got a fracture from there, but it's not in the case diary, that report. Fracture in the middle finger
Finger is fractured.
by Chandon.
Petitioner submit.
By Chandon, the petitioner number 5. He has hit with the iron rod and there he got a fracture in the middle of the.
Submits that there was a dispute between the petitioner and associates on one hand and the victim who had supplied public address system in a festival. They have been falsely implicated. He prays for answerable. Learned lawyer for the state opposes the prayer. Learned lawyer for the victim submit. He had suffered fracture wound. We have considered the materials on record. Victim had supplied a public address system during a puja festival. The system was not operating properly. A dispute cropped up. petitioners assaulted the victim. Most of the injuries are not grievous. Victim suffered most of the injuries apart from fracture on a finger. Injuries are not grievous under such intention to under such circumstances, we are inclined to grant anticipatory bail to the petitioners, subject to condition meet investigating
The
officer.
petition number 5 has done that. Lordship.
Finger.
Lordship, let's see.
Next.
Most of the thing has not
Apply
been
for
yes,
the-
but simple is there.
Like in a
Put it there.
drunken condition, the deceased met with an accident in railway track. But thereafter, father
Murder.
like allegation of murder.
Murder.
Like,
This is an accident. Matlab, is the statement of the driver. Matlab, they were last seen together. Okay. Thereafter, matlab,
Petitioner
this
submit
petitioner
that
went away.
victim
They were all
was
drunk.
in an inebriated condition and suffered accident in the railway track. He has been falsely implicated. He prays for anticipatory bail. And a lawyer for the state opposes the prayer. We have considered the materials on record, including statement of the locomotive, which which had run over the victim. The driver stated that victim, the driver,
no one else was around.
Driver stated that the victim had suddenly come in front of the train and suffered injuries. Accordingly, we are inclined to grant it.
okay. But two petitioners.
Okay. Next. Driver of the locomotive.
Lord, on the last occasion, your lordship had
For the appellant, blood. Mr. Nundi was definitely that matter, not very lordship.
Not this week.
Hearing your lordship.
Not this week. On the prayer of the state, adjourn this week. Thirty-four.
34.
B, so lordship, I am for the appellant.
He just passed out. He just passed over my lord.
Why?
34, I think.
Why pass over?
Lordship, I am appearing in 34.
34. Be competition. Who will have?
I am appearing yesterday. I moved this matter before your lordship.
Played by Shomi Ganguly.
State.
Okay. Your lordship heard me yesterday, lordship. 7 years, 4 months in custody. There was a fight. There was a land dispute on co-share. So they were making a attached proof. Objected.
Appellant is in custody for over 7 years. Didn't we call for the lower court record? This matter? When have you filed this appeal? After 5 years. Why?
There was a, he doesn't have any family, close family.
So better he stays for a couple of more years.
No,
Ah.
7 years.
And we dispose of the appeal.
7 years, 6 months.
What is the use of keeping this? We call for the records and dispose of them.
Kindly, guys. Kindly, guys.
This practice will be encouraged. After 5 years in jail, everyone says that if you come after 5-7 years, judges say that appeal is not heard and granted bail.
My lord.
It is not that.
Huh.
It's not that case.
Appellant is in custody for 7 years. He contends incident occurred on the spur of the moment and he had no intention to commit murder. He prays for suspension. The appeal is not ready, and he prays for ready. He prays for suspension of sentence. Learned lawyer for the state submit eyewitnesses implicate the appellant. The eyewitnesses stated appellant had hit the victim on the head, resulting in his death. He have
produced two documents regarding two the evidence regarding the evidence of the doctors, one of the injured and of the deceased. In there, specific names have been taken by the.
We have considered the materials on record. Incident occurred over a land dispute. Whether the appellant intended to commit murder has to be assessed during hearing of the appeal. Appellant has suffered imprisonment for more than 7 years. Paper books are not ready and appeal have not been prepared and appeal is paper books have not been prepared and appeal is not ready for hearing. Under such circumstances, we are inclined to suspend this.
I'm highly obliged.
Next,
Lordship knows Ranjan Chakra.
heart attack.
Yes.
I heard Mr. Ganguly say
same situation.
Still in ventilation.
Please, Malad. Malad 302. Life. Malad in custody.
103.
It's only Malad 302. So like
103.
Malad husband, Malad.
Then
8 years after Malad, the marriage, Malad.
So what?
But the way she died, Malad, the mother-in-law was at house. The 6 years old child was in house, Malad. They were never examined, Malad. Malad, she's the testimony of PW1, Malad, the de facto. It'll give it. It's only on, my lord, extrajudicial confession, my lord, which was according to PW4, who was the neighbor. It was told to him that, look, I have committed the murder of my wife. Now you come and do something. The village police.
You are Sadananda.
Only my sole accused, Sadananda.
He is the sole accused.
And there is no other evidence against me, my lord. Now, husband, wife will be staying.
How did she die? Tell us.
Well, accidental, my lord.
You accident.
Well, that's PW, post autopsy's opinion, my lord. She's, my lord, PW 16. Sorry, my lord, 15. I'm sorry. PW 15, my lord, cross examination. Injuries might be accidental as well.
Appellant.
No, I am in custody over 5 years, my lord.
Appellant.
No, my lord, let the appeal be heard out, my lord. In the interagnum,
Nobody injuncts the hearing of the appeal.
no, my lord, in the interagnum, my lord.
The suspension of sentence is denied.
My lord, kindly appreciate, my lord, what has come on board is, my lord, that we are staying together. The mother-in-law was there.
We can't send you to a place where she is. So you repent where you are staying. All right.
Mother-in-law was not examined. 6 years old child was not examined. The main evidence, my lord, piece of evidence which was relied upon against me was, my lord, extrajudicial confession, my lord, which cannot be the substantive piece of evidence. But the doctor said that injuries might be
not substantive.
extrajudicial. Can with deepest respect, whether a conviction can be based on that.
Yes,
That may
other
be.
circumstances extrajudicial.
Other circumstances are.
They're in the house.
I'm the husband, but I'm supposed to be in the house.
Correct. And but your wife is not supposed to die.
Accident.
Husband and wife are supposed to be in the house, but wife is not supposed to die.
No, my lord, Caesar witnesses turned hostile. The autopsy said the injuries might be accidental as well. And this is my lord, only one page. If I may just request your lordship, but this PW1 cross-examination, my lord, I just show one portion to your lordship. But kindly comes to inner page 3, last 5 lines, my lord. There is a settlement arrived at money offered, my lord, according to them, asked for as such, my lord. Money demanded, and it was the second marriage of the lady. PM report. My lord, the PM report. No, we have. No, no, oh. Well, I just, well, this is the PM report which was supplied to us. This was the second marriage of the lady. The first husband committed suicide.
Sure. Appellant submit. There is no direct evidence connecting him with the murder. PM doctor opined injuries may be accidental. Minor child of the couple was not examined. He is in custody for 5 years. He prays for suspension of sentence. Learned lawyer for state opposed the prayer. We have considered the evidence on record. Appellant is the husband of the deceased. On the fateful night, he was on the day or night? Night. He was present in the house when the deceased suffered. Fatal injuries and died. Good stuff. He made extrajudicial confession to neighbor that he committed the murder. Injuries noted in the postmortem report. So injuries in PM report discloses injuries on the face and head, on the head. Full stop. Or during opinion of the PM doctor, during cross-examination, opinion of the PM doctor that such injuries may be accidental is a theoretical possibility. In light of the aforesaid clinching evidence on record, and as sentence is one of life imprisonment, we are not inclined to grant a suspended sentence. Paper books be prepared. TCR arrested. Paper books be prepared within 6 weeks. Oblige.
Dying declaration আছে না ওটা থেকে start
To dying declaration, one was made to the witness as well as to the dying declaration at the statement bureau.
My lord, 12 years in custody, my lord. This is the first time I'm coaching your lordship, my lord. The appeal has been filed. My lord, the lady suffered burn injury. She made a statement before the doctor, which does not implicate me. My lord, PW 9 and 10 are the two independent witnesses who took the lady to the hospital. This is the evidence, my lord. Both say that she narrated that she suffered burn injuries accidentally. My lord, immediately upon being taken to the hospital, she narrated about the incident to the doctor. The doctor is PW 13. The doctor also says that lady narrated that she suffered burn injuries. 3 days later, PW 9, 10, 13. This is the original exhibit, copy of the exhibit. The first 9 and 10 in cross-examination and 13 is the doctor.
but the patient party was
Now, 3 days later, My lord, the parents come into the picture, the police come into the picture. Another now declaration is recorded by the police. Now, which implicates me?
Where is that?
That is, my lord, also I have, my lord, in that. Now, there the statement is said to be taken in presence of a doctor called Dr. Gaurav Behera. He is neither examined nor in the, my lord, exhibit. I find his signature also.
Where is the?
My lord, may I find it out? I have.
কত ছিল পেজ 17 ছিল হ্যাঁ 17 7th
This is with the
5th টা কোথায় এটা তো ভাঙ্গুরে
now, my lord, and this is 3 days later. My lord, with lordship, kindly look into
Your lordship-
PW13 also. PW13, the doctor, I handed over the evidence.
When the judgment was delivered?
August 2024.
7th August 8th August
And 12 years I am in custody, my lord.
PW13.
My lord, hinges on 306 or 302, my lord, either way.
নেই
PW13, my lord.
লিখে রেখেছি স্যার
And the
Rating 20.
PW,
Rating 25.
এটা
Yes,
শোনো
Miss
না।
and
Khan.
one more
Yes,
thing.
sir.
My lord. PW10 is the independent witness who took her to the hospital. He made a statement before PW10 saying that this was accidental in nature. PW10.
This is exhibit. Your lordship, may kindly see this exhibit 9. Exhibit. It is exhibit. কত number? Your lordship, it is stated as stated by the patient along with the patient party, and the patient party is the husband who had taken her, your lordship.
My lord,
If a husband wants to murder his wife, will he take her to the hospital?
Your lordship, there is another dying declaration
They are
also.
again asking you,
Yes, sir.
since you are saying that the husband took her to the hospital, will a husband setting a wife on fire again carry her to the hospital?
Because of the pressure of the neighbors.
It was because of the pressure of the neighbors, your lordship, they had
Because of the
come.
pressure of-
And
But
the
the
son,
neighbors say otherwise.
and the son had
The
also,
neighbors say otherwise.
yes, that is there, your lordship.
Appellant contends that the victim housewife suffered accidental birth. He had carried her to the hospital. Subsequently, she was tutored and made a dying declaration implicating him in the murder. He is in custody for 12 years. He prays for suspension of sentence. Then a lawyer for state opposed the prayer. She contends that husband was present. Appellant was present when the appellant was present at that. She contends the initial statement in the medical papers showing victim suffered accidental death, accidental burn was on the tutoring of the husband. Full stop. Subsequently, she made a more elaborate dying declaration, a declaration implicating him. We have considered the materials on record, evidence on record. Appellant is the deceased's husband. Victim suffered burn injuries. She was taken to the hospital by the appellant and other neighbors. PW 9 and 10, the neighbors who accompanied her stated she suffered accidental burn. Medical report, medical report also discloses accidental burn. Subsequently, victim made a dying declaration stating appellant had set her on fire. Full stop. Ms. Khan argues that the initial dying declaration was on the husband at the behest of the husband. We behest of the husband, and the subsequent dying declaration ought to be relied on. On the other hand, Mr. Mitter contends the subsequent dying declaration was tutored by the parents of the victim. Full stop. This dichotomy requires to be thrashed out during hearing of the appeal. It may not be out of place that the appellant, out of place to note, immediately after the incident, the appellant had rushed the victim to the hospital along with neighbors. This conduct prima facie militates against a case of homicide. Full stop. Under such circumstances, appellant has suffered incarceration for 12 years. Under such circumstances, we are inclined to suspend sentence. Paper book be prepared within 6 weeks.
Obliged, my lord. CJ Malik.
Next. Yes, Mr.
But your lordship called for a report or the others have preferred appeal or not. The 4 persons were convicted.
4 are before us.
All have been. 4 appeals have.
4 are there.
All have prayed for
No, one has not prayed for cancellation. Vishnu has not prayed for suspension in item 40. The rest have prayed for suspension.
So I make my submission. But the victim, the person called Borun, is named Nepal Shah. Nepal Shah was running a ration shop in the locality. Nepal Shah had some disputes with the appellant with regard to issues, local issues. On 10th of December 2021, after closing the shop, he was returning home riding on a scooty along with his employee PW2. PW2 is the only eyewitness. It is alleged near the house of the co-accused Borun Ghosh, the appellant attacked him, fired shots, that means thereafter they assaulted him with sharp cutting weapons. PW2 is the only eyewitness. PW2, but in the chief supported the prosecution case. In cross-examination, he said that on that day the ration shop was closed and he left for his land for cultivation, meaning thereby he was not there at the time of incident, and on that day ration shop was closed. So the question of he and the victim attending the ration shop does not happen. This is the only eyewitness. There is no other evidence.
Yes. When the incident, who else is there?
Borun Ghosh and Taroknath Shah.
You adopt the submissions. Anything more to add?
Well, I can show the evidence to my understanding.
We accept that. Yes. When the incident
The
occurred.
incident took place around 7:30 to 8. The usual ration shop hours is till 2 p.m. Now, if your lordship kindly comes to my lord, internal page 26 of the judgment. That's the PW2s. On that day, whether there was any writing work in the shop? Yes. Whether on the date of incident, the ration shop was open. In the morning, the shop was closed. It's the version of the prosecution that around 7:38 when they were coming back. So this is not an incident of the morning. Even if it had been closed in the mornings, how does it help the defense?
Incident is when?
Incident is 7:30 to 8 in the evening when they were coming back, as they say.
Correct.
So, the prosecution case is after closing the ration shop, they were coming back.
Right.
Riding on the scooty.
Right, we'll explain that, Mr. Basu. Appellant's content, the prosecution case is hinged on the evidence of this whole eyewitness, PW2. PW2 is wholly unreliable. He admits in chief, he stated he was accompanying the victim in the evening after closing ration shop. But during cross-examination, he states that the ration shop was closed on the said day. Ration shop was closed in the morning on the said day.
Ration shop was closed on that.
All right, closed on the day.
Morning or night, that did not
It
say for
is
ration shop
closed
was
on the day. Accordingly, the witness, this wholly improbabilizes the genesis, the presence of the witness at the spot and the genesis of the incident narrated by him. Hence, appellants may be enlarged on bail. Learned lawyers for the state oppose the prayer. They contend the ration shop was closed in the morning, but the incident occurred in the evening, closed in the morning. This has no impact on the incident which had occurred in the evening when PW2 was accompanying the victim who had been murdered by the and had seen the incident. Full stop. We have considered the evidence on record. PW2 is the sole eyewitness. In a case based on solitary eyewitness, the court must be circumspect to satisfy itself with regard to the quality and integrity of his deposition. Appellants have appellants have sought to improbabilize PW2's presence on the score that the ration shop, on the score that that PW2 and the victim could not have been returning from the ration shop as the shop was closed on that day. Full stop. Reading the deposition of deposition of petitioner PW2 must be read as a whole and not in a piecemeal manner. He PW2 stated that he, along with the victim, was returning from the ration shop in the evening. During cross-examination, he admitted that the shop was closed on the day, but he also stated that they were doing writing work in the shop. Full stop. Reading the deposition as a whole, it would mean though the shop was open to the public, was closed to the public, writing work was going on, and in the evening, he, along with his employer, that is the deceased, were returning from the shop when the incident occurred. In light of the aforesaid evidence, in light of the aforesaid evidence on record, now it cannot be said that PW2 is wholly unreliable. On the other hand, his deposition is corroborated by medical PM Doctor PW 17. Hence, we do not find it prudent to suspend the sentence of the appellants. Appeal shall be heard. Paper books, PCR received. Paper books be prepared within 6 weeks. TCR has been received. A are minor, defects are minor, be ignored, paper books be prepared within 6 weeks. I think. Cancellation.
The number perhaps is wrong. The cost title is also wrong. But
Not this week.
I mean, it's come for the first time. Should we serve and come back if your lordship permits?
The number, etc. wrong. So let is not this week.
Well,
Next. Southwood.
46 year
Yes,
lordship not fixed yesterday, not this week.
not this week.
কালকে not this week.